Well, the point is, I think it's for Parliament, the democratically elected Parliament, to set laws and for the courts then to interpret them. But because the ECHR is so vaguely worded, it means Parliament essentially can't legislate precisely to say what should and should not kind of count as a right and who should and should not be allowed to remain. Parliament has essentially been circumvented and trumped, as it were, by the way these ECHR rights are being interpreted. The courts are inventing novel and very expansive ways of interpreting these articles, which no one ever thought about.
Because you want to change the law and change the human rights law in this country because you're not happy with how judges have been using it. And this came up recently in Parliament. Both your leader, Kemi Badenoch, and the Prime Minister both made criticisms of one particular case. But I just want to read you and our viewers what the most senior judge in England and Wales said. Lady Chief Justice Baroness Sue Carr said the remarks were unacceptable and conflicted with the duty of politicians to uphold the rule of law and respect the independence of judges.
Well, I think she's wrong. I think it's reasonable for politicians, whether it's Keir Starmer, Kemi Badenoch or me, to comment on these judgments, particularly because these judges are inventing new interpretations. They're essentially inventing new law without reference to Parliament. That's what the ECHR has given them the power to do. And what we're saying is no, UK judges should follow UK law that's been passed by Parliament. They're still independent, they're still applying the law, but the law set by Parliament, not stretching the elastic. Now, it's important to say that in this proposal, we are still saying in the ECHR, so people can still appeal to Strasbourg, but many of these most ridiculous judgments that defy common sense come from the British courts.
But why not then?